then Rex, Susan, that would be, yeah. I can't do the smartwatch thing. I don't want to be that connected, tracked. Oh, I know we were okay with these questions. Next time, if and when I do this again. Oh, yes. Hi, everybody online. Thank you for joining. For the attorneys, this CLE is advertised for attorney participation. So attorneys in attendance, if you could online put your name and your bar number in the chat, that will help us report that information to the state bar. And then I need to get a little list going for this. Yes. Yeah. Hello. Yeah, do you want to check our volume real quick? It's good for everybody? Okay. Look at all these awesome attorneys showing up at noon on a summer day. Thank you, guys and gals. Hi, Judge.
Hi.
Well, I think I'll go ahead and get started with just some opening remarks so that that doesn't cut into our actual CLE time. Thank you all for coming in person, and thank you to those of you registered online. The idea for this CLE really came about in conversations within Montana Trial Lawyers Association in regard to some of the questions that I've heard and that others within the profession have heard and had related to the clerk of the Montana Supreme Court. So that's really what generated this content. We advertised, MTLA advertised this CLE with our panelists here on many different mediums. And so, what we are working on right now is establishing CLE credit for your attendance. So, please, those of you in attendance, make sure you put your name and bar number on the written sign in sheet. And then, for anybody who's joined in the last couple of minutes online, please online also put your name and bar number in the chat. And that will allow us to submit that list of attorney attendees to the Bar Association. So my name's Erin Farris-Olsen, and I have the pleasure of doing some small introductory comments and then largely facilitating the panel today. And we have with us Justice Cotter, Rex Rank, the former deputy clerk of the Montana Supreme Court, and Susan Fox, the former executive director of legislative services. And I'm hoping they'll be encouraged to say a little bit more of their background and why they're part of the panel today when they provide their remarks. I have a couple of questions that were compiled by people who are interested in this program prior to. And then if we have time at the end, would love to entertain some additional questions from the audience. So, yes, thank you all for coming. The clerk of the Montana Supreme Court is a position that was initially established in the 1889 Montana Constitution. And at that time, all elected positions within the state were partisan. So that's one question that comes up a lot about this position is why is it partisan? And the answer is quite frankly, because it always has been. And there were efforts over in the 1900s, in 19, my notes here, I believe 35 specifically, to make judges nonpartisan. And that shift was made, and then actual voter participation dropped off as a result of making that shift. And so judges were made partisan again to try and engage more voters in those races. Now, by the time 1972 Constitutional Convention came around, it was debated quite heavily, but ultimately, decided that judges across the state would be nonpartisan. And the clerk and the state treasurer were removed from the 1972 Constitution. So the clerk of the Montana Supreme Court is an independent office. It's elected. All of the deputies and staff of the office serve at the pleasure of the clerk, and that is established as a partisan office in statute. Now, there are district court clerks throughout the state, and the decision was to just allow district courts to decide for themselves, essentially, whether or not they would have partisan races. Still, a large majority, I don't know the exact count, but a large majority of them are still partisan races. And so, yeah, so the clerk exists by statute, and the I'm trying to think if there's that Rex is going to get into kind of the details of the job and what the statute outlines. Is that pretty much the historical context that we were looking for? Okay. So the focus of this conversation, though, is also the ethical considerations, and some of those are rooted into the nature of the position of being partisan, nonpartisan. What does that mean? Having a race that is a certain way, what does that mean in terms of carrying out the duties of the position? So that's where I'm going to pass it over to Justice Cotter, who's been really involved in Montana judicial ethics, and take it away.
Yeah, I thought it was on. Okay. All right. Okay. As a former justice, I was on the Montana Supreme Court for 16 years. And as a former justice, I obviously have some familiarity with the office of the clerk of the court. And I was fortunate to serve on the court at the time that Ed Smith was the clerk and Rex Rank was the deputy clerk for all those 16 years. And they obviously, I feel they honorably served the duties of the office. And it's nice to be up here with Rex today. So this afternoon, I am going to explore the ethical, legal, and practical obligations of the office of the clerk of the court. As Erin mentioned, the clerk is chosen in a partisan election, and the term of office for the clerk of court is 16 years. Although the clerk is an independently elected official chosen separate and apart from the justices, the clerk's election requirements and duties are set forth under Title III, which addresses the judiciary. Section 32402 MCA sets forth the duties of the clerk, which include the control of the Supreme Court docket and filings, management of the appellate process, and the licensing of attorneys. And like all elected officials in Montana, the clerk of court is obligated to take an oath to support, protect, and defend the Constitution of the state of Montana. Now, when Erin put together this program, she asked me to address the significance of the Montana Code of Judicial Conduct and its application to the conduct of the clerk of court. The Code of Judicial Conduct was revised. I was chair of that revision panel in 2007, I believe. And it was revised, and it imposes obligations upon judges of all stripes, all the way down from the Supreme Court, water court, district court judges, judges of courts of limited jurisdiction, etc. And it also imposes ethical obligations upon judges and at times judicial or candidates who are running for judicial office. But by its terms, it has no direct application at all to the office of the clerk of the court. It applies only to judges and, as I said, in certain situations, people running for judicial office. Now, the Code of Judicial Conduct does require judges to ensure that all members of their staff, such as judicial clerks, administrative personnel, etc., act in accordance with the judge's obligations under the Code of Judicial Conduct. But again, that does not apply to the independently elected clerk of the Supreme Court. So, where, if anywhere, are the rules that directly connect the Montana Clerk of Court to the Supreme Court itself, and any rules governing the ethical obligations of the Montana Clerk of Court? First, let's talk about the legal obligations. Rex will address the importance of the clerk's independence and protection of court documents for the benefit of the public. But I'm going to address the statutory obligations that the clerk of court has to the Supreme Court. Two statutory references are particularly relevant. First, Section 32402, which sets forth the duties of the clerk, which I previously mentioned, contains an interesting catch-all phrase after spelling out the clerk's specific duties. Section 3-2-4021G provides, quote, "It is the duty of the clerk to perform other duties as may be required by law and the rules and practice of the Supreme Court." So this provision does succinctly tie the duties of the clerk of court directly to the elected Montana Supreme Court. For example, the clerk is required under the Montana Rules of Civil Procedure to promptly notify each party of the Supreme Court's decisions and provide a copy of the decision to the parties. That's Rule 21 of the Rules of Civil Procedure. In addition, the clerk is obligated under the Supreme Court internal operating rules to promptly deliver copies of briefs to the justices once briefing on a matter is complete. Second, Section 3-1-1115 addresses the powers of every court within the judiciary. It provides every court has the power to control, in furtherance of justice, the conduct of its ministerial officers, and this is the important part, and of all other persons in any manner connected with a judicial proceeding before it. So I don't think it would be stretching the language of the statute to conclude that the clerk of court, because it is definitely connected to all judicial proceedings, would fall under that catch-all phrase. Thus, a court has a statutory power to control the conduct of the clerk in furtherance of justice to the extent that the clerk is in any manner connected to a judicial proceeding. Excuse me, I have gnats. All right. Yet, again, are there any established rules of conduct in Montana that govern the clerk of court? There are not. So, one of the things in discussing this with Rex earlier, Rex pointed out that there is a national organization that has enacted a code of professional conduct for appellate court clerks. Again, this is a national, not a statewide organization. And during the years that Ed Smith and Rex Rank were the clerk and deputy clerks of court, both were dues-paying members of this National Conference of Appellate Court Clerks. The code of conduct of this association does set forth standards of personal integrity and professional conduct that should apply to all appellate court clerks. Now, much like the Montana Code of Judicial Conduct, this code provides that clerks
Really like you.
that they like me, that they probably will. This code provides that the clerks of court shall avoid impropriety and the appearance of impropriety in all activities, and it obligates clerks of court to treat all attorneys and litigants with respect and dignity. Clerks of court should abstain from any public comment on the merits of a proceeding according to this code, and they should always support the reputation and integrity of the judicial system and should not make any comments that might undermine public confidence in the judiciary. And importantly, the clerk of court under this code should avoid political activity which may give rise to a suspicion of bias or impropriety in any manner pending or impending before the court. Finally, under this code, the clerk of court is obligated to refrain from discriminating against any litigant or attorney based upon their based upon their political affiliation. Now, membership in this national organization is voluntary. It is not mandatory. I have no knowledge if the present clerk or deputy clerk have continued this tradition of membership. But whether they're members or not, there are two provisos about this National Code of Conduct that bear noting. First, no appellate clerk of court is required to be a member of this national organization. And second, this National Code of Conduct is aspirational only. And let me explain what I mean by that. When we revised the Code of Judicial Conduct in 2007, we were actually the last state in the union to have a code of conduct that was more than aspirational. The canons in those days simply told judges, you should do this, you should do that. It did not obligate judges to adhere to any particular code of conduct. So while the national code sets laudable standards applicable to clerks of court, it is not compulsory. It too speaks in terms of what a clerk should do and not what they must do. So it is like the canon of judicial ethics, because under that canon and under this particular code, there are no mandatory standards of conduct at all. Thus, that violation of any of these aspirational canons cannot result in a range of discipline at all. Because there's no mandatory nature to the code, there would be no range of discipline like there is under the Code of Judicial Conduct now. No admonition, no suspension or removal from office for violating aspirational standards. So, the upshot is that the Montana Clerk of Court plays an important role in the managing and protecting of court records for the benefit of the public and is obligated to perform duties as directed by the Supreme Court. But beyond this, there is at present no established code of ethics applicable to the Clerk of Court, and thus no established mechanism for addressing, much less disciplining, any perceived ethical violations by the clerk. Now, I, for one, believe that the Clerk of Court's office would benefit from an established code of professional conduct that provides some guidance and defines what is appropriate conduct and also sets forth disciplinary consequences for violation of the mandatory code. It is always nice to peruse the Constitution on occasion when you have nothing else to do. And when I was perusing the Constitution just a few days ago, I discovered that the Constitution of Montana demands a code of conduct for this particular office, or for this office. Article 13, Section 4 of the Montana Constitution which is, I think it is entitled, let's see here, General Provisions. Section 4 is entitled Code of Ethics. It provides, quote, "The legislature shall provide a code of ethics prohibiting conflict between public duty and private interest for members of the legislature and all state and local officers and employees." So I think that there is constitutional authority for whoever becomes the next clerk of court to make a formal request to the legislature that there be a code of ethics enacted that governs the office of the clerk of court. So that's the extent of my comments. I would welcome any corrections or additions from Rex or Susan or Aaron, and your questions later after we're finished. Thank you.
Thank you, Pat. One very minor correction. The term of office is 6 years, not 16.
Oh, oh sorry. You'd
That's
still
okay.
be in office,
Yeah,
maybe.
yeah, perhaps so.
Okay.
Perhaps
Sorry.
so, but in any event.
Thank you.
Thank you, Aaron. Thank you, Susan. And can you check your mic, please? Whoop. Do I have to be that close? Okay. Oh, how's that?
There you go, try again.
How's that? Okay. Thanks, everyone. So I'll scoot up here. Thank you, Aaron, Susan, and Pat. It is a pleasure to be with everyone today. A little bit about me. So I started actually in the clerk of the Supreme Court's office in December of 1990. Just gotten out of graduate school. Skeff Sheehy and Diane Bars were on the court at that point. Then I had a break in service and where I went back to graduate school for all of that time, I should say, in graduate school, I was serving as the first assistant clerk and then deputy clerk for, I would say, almost 24 years as the deputy clerk of the Supreme Court. I served in that position until January of 2019. I did run for the office and was not successful. And so for the past 5.5 years, I've been with the Department of Natural Resources and Conservation in an administrator job, and recently have retired. I've just retired, having 30 years with the state. So one of the reasons I say all that is that I am slightly removed from the day-to-day duties, and my responses and kind of comments here today are based on really my own personal experiences, my own viewpoints, and I can speak to how Ed Smith and I attempted to, what we wanted to bring to the office in terms of service to the people of Montana and the court. And one thing I would like to say about, the clerk of the Supreme Court, it's not a very sexy position, if you will, but it's an important one, and always kept in the foremost of our minds. And I would say it applied to our staff as well, is that we recognize that Montanans have both the constitutional right to know and to openly observe how government works, but also the constitutional right to individual privacy. And the independent clerk bears a responsibility with regard to the court records that come before the court. So, for me, all Montanans, no matter their background, status, influence, everyone deserves to be and should expect that their elected clerk, will protect the privacy when the law requires, and also ensure access to the court records. And it also protects the court, by the way, when you have a different independent office that is controlling the access to the record. There's no there's no instance there or appearance that the justices are somehow controlling the record before it. That is the purview of an independent office. So it protects the justices and it protects the court in that same way. So um, also kind of, I've always thought it, and maybe perhaps less so, but the judicial branch, less so in these days, but to me, the judicial branch was the most remote branch, considered the most remote branch of the three branches of government. And so having an independent clerk who can guarantee that access and protections to the public, I think was even a little bit more imperative for the public to have trust in the institution. I'm going to talk a lot about that because overarching almost all that we did was to promote a sense of trust and impartiality with the judicial, with the court, right? So that people will have trust and have faith in our institutions. Because to me, that's no small matter today and in our society and within our state. I think that's really important. So just kind of with those brief statements, Aaron asked me to talk a little bit about the day-to-day responsibilities that the clerk of court have. And I would say, so from a day-to-day perspective, each day we're gonna is met with those couple of ideals. How can we serve the public? How can we also serve and facilitate the court? And and so we have this very small, narrow, structured part of the code, Title 25, Chapter 21, which lays out the process of an appeal. Um, so education, actually, I would say was a large part of what we did, and certainly what I did on a day-to-day basis. We had a number of folks, and I can only assume it's continued over the past 5 years, who represent themselves. And so they may come to the court and not, having never been, these are adversarial proceedings, could be pretty daunting, I would think. And so always wanted to keep in the foremost of my mind, and I think our staff's mind, of just educating folks to say, look, this is what you can expect. The process in the narrow, again, the rules of appellate procedure is not a complicated one. There's a upfront piece where the record is being built by the briefing of the parties, and then there's a handoff to the court, and where then the court takes it for their consideration. So um, I think just being able to explain to people, like, this is a very structured process, and there's no new evidence, by the way, right? That's a big one. A lot of people will think, well, I'm going to have to be presenting something new, or there's something. No, there's no new evidence. The record is what it is, and you just have to make your arguments. And here's the time frames within you have to make your arguments. Um, so just the fact of letting people know what they could expect, um, I think would go a long way with sort of you know, maybe taking a little bit of the scariness out of the process for people who are representing themselves. And also, I would say, not everybody's an appellate attorney. Like, I know there's a couple out here in the audience I can see today that do this every day. There's some folks, whether they're new attorneys or folks who have been practicing for a while, who they just don't do appellate work. And so for them to have an independent place to call, I think helped promote uh, the that trust within an institution. It helps it, and I've had numerous attorneys say, "No, I really appreciate you taking the time to explain this to me, because I don't have time to sit down and read the rules you know, light reading, and so I took great pride in that. Um, and in terms of that direct service, I think responsive service was really important to the clerk of the Supreme Court. Again, so that it can foster trust in the institution. So when when I was working, and one of the things that Ed and I made sure was that if the phone rang, you answered it. And if we did, I want to say we did have a phone recording, a recorded message. But if you got to that, literally everybody else was on the phone. And that included Ed too. So that was important to us, right? Serving the public in that way. So a little bit back, getting back maybe too much into the weeds, and you can stop me, anyone, if you don't, if this is going on a bit much. But so in the appellate rules, right, there's a notice of appeal filed with the clerk of the Supreme Court, which initiates transfers jurisdiction. And then there are, in the rules, 40 days to get the record transmitted to the court, including transcripts. So a lot of that initial time we spent working with our elected clerks of district court and the clerks of district court. Again, the majority of them are elected, and I believe the majority of them are elected on a partisan basis. I know that counties have an opportunity to review their local governments every 10 years. And so that may be changed, but so we are dealing and working together with those clerks of district court, who I know take very seriously their responsibility and their of preserving and creating a record. So we work together. Once the record gets to the Supreme Court, then the briefing schedule begins. And so we are then thinking, okay, on the front end, here comes, might be somebody coming into the office, and one of the things we worked with, of course, was to allow for electronic filing. So that actually made it our efforts for judicial economy a little bit easier, and certainly I think helped the bar. But that's all the intake, right? So we're tracking the cases as they come through. After the initial argument comes in, the response brief it comes in, and then there's an optional reply brief. And whether a party files that reply brief or not, there is a time. Let's say, for example, they did not file a reply brief. Well, once that time is run, it's the duty of the clerk to get this case to the justices. And so they're getting it they're seeing, really reading the case for the first time. And if all of the timelines are followed, that's 120 some days from the time the notice of appeal is. And that's about as fast as we would see things come through. But it's that obligation from the clerk then to hand that off to the court. And so one of the internal operating rules provided that we would do a review of cases, a periodic review of cases, to say, hey, these cases are languishing, these cases are not. So I usually did those reports, and again, I took pride in that because it was facilitating the work of the court so that they could do the important, do that important work that they had to do. Once the court is finished, they will hand the opinion down. As Pat mentioned, the important duty of the clerk is to get the notice out as promptly as we can. And then eventually, after a period of time for a petition for rehearing, either runs or a petition is filed and the court rules on it, then we end the jurisdiction by creating a document called the remediator, which in law jurisdictions are a mandate, but it essentially ends the jurisdiction. So clerk hands that back, the jurisdiction's ended at the Supreme Court, and off you go back, and that ends the matter in front of the Supreme Court. So in a nutshell, there's the process. Now, the other things the clerk does, certainly we have a role in bar admissions. We're responsible for collecting the license tax. The clerk works with the state bar for the collection of that. By the way, hasn't increased since 1989. I like to put that plug in there too. So I know a lot of things have for you attorneys out there, but that license tax hasn't increased since 89. Anyway, so there's certainly other parts of the office, but day to day, that is what the clerk is doing. But I should say, one of the things that we never do and would never do is talk about an actual argument. Like, the argument is the responsibility of the party. You would never engage with an attorney about and I can't imagine an attorney asking the clerk of court for any sort of advice on argument before the court. That's a step across the line in terms of, from my perspective. So we can talk all we want about process, and again, I think there's real value in that. And we can talk about, the mechanics, but never speak to an argument. So that's kind of the day-to-day work in a nutshell. Aaron also asked to say, what are some of the challenges? Well, I can tell you, the clerk of the Supreme Court, like many clerk of court office, there's a small staff, and there's a lot of cases that have come through. I think 909 filings was the largest year that I was part of that. And we basically had an office of the clerk and 4 other FTEs. So that was one of the challenges, was to keep all the plates in the air, keep the process going, try and stay on top of the filings. And because you can see the color of my hair in the old days, there was a lot more work in helping those filings get to the court before electronic filing. So for example, you'd get a call maybe late on a Friday. I'm driving over, my petition for supervisory control. Can you stay? And so oftentimes, I found myself in that position as well, because what you're trying to do is not be an obstacle, not be a hurdle. You are trying to facilitate and let the court make those decisions. So, I mean, that is definitely, I think, with the advent of electronic filing, some of those things have eased and are just a matter of technology rather than how it used to be. So the other thing, I guess Aaron asked me to talk a little bit about is, and I've talked already, maybe too much, but my approach and our approach in the office of professionalism, patience, of fairness, and responsiveness. And again, why do we do that? To foster trust within the courts and the institutions. The clerk is the public face of the court. You can't have a party calling up Pat and talking to her directly about a case. So, you really are representing the court, and I took that really seriously. Again, most folks are already in a stressful enough position with a case in front of the Supreme Court. And so with all of that, it was important for me to have a little bit of empathy for the people who were filing. Especially those representing themselves, but again, as I mentioned, also attorneys who, I've never been here before. So, how did we, or what did we use to adhere to that professionalism and the patience and fairness? Well, Pat spoke largely to it. Ed and I were both members of the National Conference of Appellate Court Clerks, and the Professional Code of Conduct, which was first adopted in August of 1983 and then amended in 1992, 1993, and then in August of 2009. That was important to us and for every member of the organization. And so there are 8 canons the Code of Professional Conduct for Appellate Court Clerks. And by the way, I just a little bit about that association. It was started in 1973, and there were we had as membership um, clerks of appellate courts. Not only just Supreme Courts, but intermediate um, uh, appellate courts, courts of criminal appeal, and longtime member Bill Souter, clerk of the United States Supreme Court, was a very active member of our organization as well. Um, and so back to the code, there were 8 canons, and I'm just going to just very briefly mention what each canon was. So Canon 1, the highest standard of professional conduct. I'm just going to read that one. Pardon the paper shuffle. Members of the National Conference of Appellate Court Clerks should maintain a highest standard of professional conduct and performance of their duties. An independent and honorable judiciary is indispensable to justice in our society. Members of the National Conference of Appellate Court Clerks participate in establishing, maintaining, and enforcing the law and should themselves observe high standards of conduct so that the integrity, the impartiality, and the independence of the judiciary may be preserved. In its simplest, shortest canon, perhaps the most important one, but they are all important. Canon 2, avoid impropriety and the appearance of impropriety in all activities. And Pat talked a little bit about that. 3, perform the duties with impartiality and diligently. A little bit about that responsiveness that I was talking about. Improve the law. This is Canon 4, improve the law, the legal system, and administration of justice. I think we took that very seriously when I was with the Clerk of Court's office, and I think that through our case management system and electronic filing, we were able to accomplish a long way toward fulfilling that canon. Number 5, regulate outside activities to minimize risk of conflict with official duties. So what organizations do you belong in? Do you have some avocations? And you have to be mindful of where there's a potential for a conflict of your official duty. Canon number 6, avoid political activities, which may give the appearance of bias or impropriety. And again, Pat talked about that. And I would just say on that one, working for, again, an official who was elected on a partisan ballot and knowing many county officials who were elected on a partisan ballot, once you assume that office, these are the canons that guide your conduct. I think I worked under administrations, both certainly Republican and Democratic administrations, and various different membership of the courts, which some may characterize as more conservative or more left-leaning over the years. None of that mattered to us because of the responsibility and the oath that we took to serve the people of Montana. So that's canon number 6. Number 7, seek improvement of professional competence. So professional development, that was always important. And then number 8, not to engage in discrimination. Again, Pat mentioned that. Certainly race, sex, religion, but also political affiliation. And all of that, again, to bring and promote trust and faith in our institutions. Because to me, that's, if we don't have that, we don't really have, I'm not sure what we have, I guess, and I might end there.
Right. Thank you, Aaron, and so good to be on a panel with you too. I feel very privileged. I will.
How's the sound?
Is it on? Hello? Okay. I'll start over. My name is Susan Fox, and thank you to the panel members and Aaron. I feel really privileged to be here. My disclaimer is I am not an attorney, so I'm very happy to speak with you on behalf of my experience working for the legislature for over 30 years. It's even though I was in a sense a clerk in many ways. And so I see that as you're a guardian of the process. You are there to be that liaison between the public and the elected officials. And to get so in my case, the legislative process, in the clerk's case, the judicial process. Um, I was asked to speak on kind of the trends in judicial administration, but from a legislative perspective. And as you probably all know, the legislature has had increasing interest in the judiciary. And the words that they always bring up are transparency. And I think, as both Rex and Pat have pointed out, that importance of transparency, that importance of process, so that the public knows where things are at, how to access that, how to do the process. So I think that's important. Um, it's interesting. The legislature has they changed the Judicial Standards Commission. First, they required the confirmation of the members by the Senate, and then they have changed the appointment process and inserting more legislative involvement. So the two judges are now appointed by the Speaker, one attorney by the Attorney General, and they added this legislative nomination panel. So it just shows that they're interested, they're struggling, I think, as we all do in one sense, with the separation of powers, the checks and balances. How much check do they want? How much balance? Of the two of the three branches of government, the judiciary and the legislature are really the smallest compared to the executive branch. So I think the legislature often feels that lack of power, and then you add term limits on top of it, and it has made it very hard for them to, I don't know, to maintain that sense of I don't know, I guess process or understanding what's going on. Yeah. So the legislatures had these different attempts at getting to hold the judiciary more accountable. The Judicial Nomination Commission, they also changed in 2021. They changed it so it was a direct appointment by the governor and less of a process that there had been in the past. That was challenged in court and upheld because the Constitution said as provided by law, which gave the legislature the authority to do what they did. But again, the concerns are generally over accountability, transparency. Those are the words that they keep bringing up all the time. I think the clerk's office has remained kind of under the radar. The legislature doesn't seem to be too worried about making too many changes in it. The one exception was this last year when they wanted to, in Senate Bill 230, they wanted to place the court administrator under the clerk. And I think that had more to do with the court administrator, the issues that have been arisen over the last couple of years over public records and the Judges Association, things of that nature. And so I think it was interesting that bill didn't get out of committee. But again, the terms that the sponsor of that bill talked about: federalism, separation of powers, transparency. There were no proponents for that bill other than the sponsor. And so it was interesting in the opponent's testimony to really make that distinction between the court administrator and the clerk, and how the clerk is that outward face, that public, it's where the public can access the court. Now, most public, I think, if you don't ever have to go to court, is probably the best thing, right? If you don't have to access that. But when you have to access the court, you need a place, right? There has to be a place. You can go to your elected officials. You could try to go to the courts, or to the justices or the judges, but that's inappropriate, right? So you need a place for the public to come, and that outward face is important versus the court administrator, which is very inward facing, right? It's just the basic mechanics. That's more of like what my job was, is like you've got IT and you've got somebody's got to develop the budget and you have to pay the bills and do all that work. And so that bill didn't get very far. And I just think it's really telling that the clerk of the Supreme Court has been the same since inception, right? It's always been an elected position. It's always been partisan. It doesn't seem to have a lot of uh, controversy, and I think that's a testament to that position and what its function is in the operations. The legislature, again, most recently has been very interested in the judiciary, but we've always had a Law and Justice Interim Committee that is basically the committee that meets about every 2 months during the interim, and they do issues related to the judiciary, Department of Corrections, and the world of law enforcement. In 21 and 22, the legislature had a special select committee on judicial accountability and transparency. And that's for some of those that I think a little bit of the changes of the Judicial Standards Commission. They spend a lot of time on that. And then in 2024, there's a Senate Select Committee on Judicial Oversight and Reform. So you see these terms keep coming up again and again: accountability, transparency, oversight, reform. So it's one branch of government trying to, keep track of the other branch of government. It's interesting right now, this group is looking at judicial performance evaluation. And it's interesting in the discussion, one of the legislators asked a question like, well, what's the right amount of time for a case to go through a court? And they were talking more about district courts. But to Rex's point, those timelines are very important, right? That predictability, so you know when things are going to happen. But I found that interesting because when you're bill drafting, it's like saying, how long does a bill take to draft? Well, an hour or 3 weeks, right? It's what's the substance that's important in your cases, in what's before the court. And it is, to me, it's you can see the function of just a bureaucracy in the best sense of the word, of that funnel. Like Rex said, you can't bring in new testimony. You can't do, there has to be some structure to things. And that clerk is the person that is the one that is helping to make that structure work for all of us. On the position of ethics, there is in Title II, there is a code of ethics. And it's if you've ever had to try to explain it to anybody, there's definitions for judicial officer, public employee, and then they kind of cross-reference each other. But I think any which way that the clerk of the Supreme Court would be subject to those code of ethics. But as Pat pointed out, enforcement is the issue. And the only discussion really on enforcement in there is if there was official misconduct, it would have to be brought before a county attorney would have to bring it before the court. Otherwise, it's all obsessed more with campaigning and using public facilities, resources, or anything for a private business purpose. So that is covered in those other ethics that you talked about. But again, it's like anything, it's the enforcement that's the hardest part. And the discussion on the appearance of impropriety, that's kind of like beauty, right? It's kind of in the eye of the beholder, but it is what I think that's important. And even though these legislative committees to me sometimes seem a little bit overbearing and they seem overly critical of the judiciary, I think the best thing is that if we remember that legislators are, it's a citizen legislature, right? They only meet every 2 years. Unless you have a lot of interaction with the courts, it's a mysterious place, right? You don't know much about it. I mean, if you get a ticket and you have to go to court, my dog, didn't have his tag on and have to go to court. That's a scary thing for anybody. And so the legislators, I think they've got, by definition, the people that they represent bring their concerns about the court to the legislators who then have to look into it. So the best thing I think about these committees is that it brings people together and they can have a place to ask questions, and it for the court to have to explain about filings and numbers that go through and how long and the resources and recusals and all that. As irritating as it is, I think it's a very important part of the public education about the judiciary and the legislature about the judiciary, so that when they try to develop public policy regarding the judicial process, that they're the best informed that they can possibly be. It is interesting. They're very, I think it's just a frustration, right? We're all frustrated by some institution or other. Government is a frustrating thing, but we can't really live without it. And so I think the important thing is that positions like this, especially whether they're elected or not, whether you're nonpartisan or partisan, there's that standard of ethics, that the reason that government exists is to serve the people. And so this position, the clerk of the Supreme Court, is very important because it is that interaction, that outward facing liaison to the public. And luckily it's kept its head under the radar, and the legislature has not necessarily gone after that position as much as they have other parts of the judiciary. But I think it is that symbolism. If the clerk of the Supreme Court is transparent and outward facing and helping the public, that can only reflect on the justices and the whole judicial system, so that we can have trust in our government and keep that transparency. We all know how the partisan world is right now, and it's just crazy. And so I think we all kind of need a safe harbor where it's like, no, this is where I can go, I can get the information I need, I can get the assistance I need, and they can help me access that the administration of justice and access that due process that we as citizens expect, and have those rights in our Constitution. That's all. Thanks.
Well, that's wonderful. I feel like some of the prepared questions I had were mostly addressed in y'all's comments. I do want to follow up on a couple of things. One, I guess we'll go back to Justice Cotter. I'm curious how our ethical standards compare to other states. And then I'm also curious your perspective, because as I understand it, you also do training for judges on campaigning and campaign tactics. And the clerk is sort of at this interesting intersection of being a partisan, non-attorney elected position, but that also works for the court. Do you have any comments on both kind of two-part, how our ethical standards compare to other states? And then two, your perspective, having worked in the field of training judicial candidates, and what takeaways there might be from that in terms of what we could expect of a candidate for clerk of court.
Well, I have not explored what other states do necessarily. Other states may have a code of conduct applicable to their clerks. I just don't know. The only one I'm familiar with is the one that Rex mentioned and that I mentioned. We have a vast number of judges in the courts of limited jurisdiction. That is, if you talk about the face of the judiciary, it's the courts of limited jurisdiction all over the state. And there are, I'm going to overstate or understate, but there are well over 200 judges in the courts of limited jurisdiction. Many of them are not attorneys. In some of those courts, they do not require a law degree for a person to be a judge in the courts of limited jurisdiction. So every other year, those judges are obligated to attend a 3-day conference in which they review their obligations, they review how to operate their courts, they review certain crimes that may be coming before them, and how to handle those. And then for the last probably 15 years, I have been responsible for teaching them ethics in conjunction with Professor Peggy Tonin, who is a professor at the law school. The two of us do this together. As I mentioned, the code of conduct, judicial conduct, applies to all judges, including judges of the courts of limited jurisdiction. And it's not something that is, that is inimical to a person who is not a lawyer and who is serving as a judge. For example, one of the things that we talk about frequently in the courts of limited jurisdiction training is that as a judge, you have given up certain rights. You don't have an absolute right of freedom of speech. You are not free to go about making political demands or observations as a judge, or you are subject to discipline under the Code of Judicial Conduct. You're not free to go out and drink too many drinks and be in public and be where people can see you and see your behavior and come to the conclusion, well, he or she can do that, but the rest of us get in trouble. In other words, the interesting thing about the Code of Judicial Conduct, and I think also connected with the code that Rex addressed, is that it applies to a judge in their personal as well as their professional life. Most codes of conduct, professional codes of conduct, address what you do while you are at work or in office. They don't address your conduct in your private lives, but the Code of Judicial Conduct does. And that's one of the important things that the judges have to learn as part of the ethical training that they go through. So yeah, it's a 3-day program, and it's really, really important so that these judges can apply justice and understand their ethical obligations when they're in their communities.
I think I could add to that, just as Pat alluded to in the preamble of the Code of Professional Ethics, the National Conference of, reading here from it, National Conference of Appellate Court Clerks, mindful that the character and conduct of its members should never be objects of indifference, and that declared ethical standards should become habits of life, adopts these principles, which should govern the personal practice of appellate court clerks. The administration of justice requires appellate court clerks to adhere to the highest ideals of personal and official conduct.
One question that comes to mind, I have one more, but I want to see if there's anybody in the audience that has a question because I don't want us to run out of time. But one thing that came to mind for me, and as many of you know, I was the court help program administrator for a number of years. So I worked with self-represented litigants across the state, not so much at the Supreme Court, but I don't know that it's that common knowledge that the Supreme Court actually has quite a few self-represented litigants. And one of the things that I found as an opportunity at the time was to do training in terms of legal information and legal advice, because the boundaries that you mentioned, Rex, in terms of what you can and can't share, because the clerk of the Montana Supreme Court is not required to be an attorney, which is a fact about the job that's also worth sharing. Does that come up for the clerk as well in terms of the limits of what you can share with either self-represented litigants or attorneys? Has the unauthorized practice of law ever come up as a factor?
Yeah. He ran for both.
Yeah, there have been people over the years who have attempted to challenge the requirements of what you need to get a law license, for example, and what you would need in terms of the requirements for becoming a judicial officer. There was one former legislator who routinely challenged that, not successfully, but he hasn't given up, and more power to him. But I'm not sure if that's addressing what you're talking
Well,
about.
it was actually in response to him, is it gave a chilling effect to where clerks of court were concerned about giving any information because they didn't want to be perceived as providing legal advice. So my question though is more, was that ever a factor or a conversation in terms of the Supreme Court clerk's office? What can and we cannot say to either attorneys or litigants so that we're not crossing that line? Because some of the things you said in terms of what you can't do, that came to mind to me as, well, you can't do that because that would be providing legal advice. And it's not only not the role of the clerk, but if the clerk's not an attorney, you run into that challenge as well.
Yeah, that's, I would say, I wouldn't, almost every day. I mean, this is the sort of, that is what we would instruct the staff to be very mindful of, and of course, hold ourselves to that same thing. We often would say, I cannot provide any legal advice. These are the things that I can talk about. And so when you were pressed with that, we were very clear to make sure that you were not offering anything that could be construed as legal advice. And I used to answer many correspondence, write a lot of written correspondence would come in, and that was nearly I don't know, the first or second sentence in almost every response or many of the responses that I provided. And one of the things we did, so especially if somebody was physically in the office and is, work on trying to give them something simple. We just printed up the rules of appellate procedure and filing guides. Say, hey, so if you've got questions about this, let's talk about those things. But cannot provide legal advice, and anything that could be construed as legal advice. So I wish I had a nickel for every time I said that.
I bet. Any questions from the audience? Not yet. Okay. I'm going to ask one more question just to close it up and get our full CLE hour in. But I want to mention before I do that, there are snacks in the lobby and there's little drink tickets if you want to grab a soda or another beverage of your choice and hang out and chat with the panelists or amongst yourselves after this. Please, you're welcome to it. Welcome to do that. My one final question, and this comes from some of the conversations that I've been having, is just what changes do you foresee or would you like to see in light of the trend to increase partisanship or respond to some of the political attacks on the Montana Supreme Court?
Well, as I mentioned in my comments, I would like to see a code of conduct. And I'm not in any way inferring that we need to tamp down any of the conduct of the clerks that are now serving or served in the past. But if you have a judge might express dissatisfaction with something the clerk has done, administratively or whatever. But if there's conduct that crosses the line, there has to be some sort of mechanism for formal enforcement of a code of conduct, and also to help the clerk of court's office and staff know what their obligations and the responsibilities are and know where certain conduct might or might not cross an ethical line. So that's one of the changes. I think whoever becomes the clerk of court in the next election should ask the legislature, in accordance with the provision that I just talked about, to establish a code of conduct for that office.
I agree. I think that would be helpful for the clerk of court and the clerk of court staff, and also would further promote the confidence and trust in our institutions. Back to the theme that I'm hammering. I think that's a great idea.
This is more of a comment than, but I'm curious to see how, if that constitutional initiative on the top 4 does what the group thinks or intends it to do, is kind of strip away some of that partisanship and just saying, your primaries, just the top 4 get to go. It doesn't matter for your party. And I don't know if that would, assist in allowing somebody to run for the clerk of Supreme Court without it having to be so partisan, where you could run as an independent or Green Party and not have the 2-party system be so restrictive. And so I'm just curious as to how that might affect, elected offices like that in partisanship. If it really will strip away some of that, the extremes that happen in the primaries or not. So I think a code of ethics is always a good idea for everybody. It works both ways, as you had said. It protects not only the public from somebody's inappropriate behavior, but it also gives you that guidance to say, just like your job description, you've got a recipe, you know exactly where your lines are drawn, and it helps you be that better elected official. So I think in general, the code of ethics for all state employees, that the enforcement mechanism, it is always the issue.
Right.
And so if you have, the Commissioner of Political Practices can help on the campaign stuff, but everything else, it's a little bit blurry. So anything to make that clear for everybody, for the public, and then for the person serving in the office.
Great. Well, thank you to all of our very esteemed panelists. I certainly learned a lot. And thank you again to Al and Mary at the Montana Trial Lawyers Association. They couldn't be here today. Mary's thankfully on vacation, but I really was excited to be invited to facilitate this conversation and facilitate this opportunity for us to learn more about, like you said, a position that often goes under the radar. So thank you all for coming. I hope to see you in the lobby. And thank you all of you online. Don't forget to put your bar number and your name in the chat so that we can submit those to the state bar for CLE approval. Thanks, everyone.